If the surviving spouse later dies, does their child inherit the property that originally belonged to my parent? Usually, yes, at least for the portion that legally passed to the surviving spouse. If your parent died without a will and was still legally married, the surviving spouse typically inherits a share under intestate succession. Once that share is distributed outright to the surviving spouse, it becomes the spouse's property. So when the spouse later dies, whatever is still owned can pass to the spouse's own heirs, including the spouse's child, unless the spouse's own estate plan says otherwise or a legal disqualification applies. The big detail is what kind of interest the spouse received. If the spouse received an outright share, it can be spent, kept, or left to the spouse's heirs. But in some situations, the spouse can elect a life estate in certain real estate instead, if it is properly and timely elected. And a life estate usually ends at the spouse's death, meaning the spouse's child would not inherit that life estate interest. Also remember that some assets may pass outside probate, like joint accounts with survivorship or beneficiary-designated accounts, and the way the home is titled can cause it to pass automatically to the surviving spouse. Those non-probate transfers can change what is left to be divided, and what later remains for anyone to inherit.